May I please, Your Lordship? I'd like to mention item number 6. I'm appearing on behalf of Mr. S.J.
Just a moment. You're for?
For S.J.
Respondent number?
Respondent number 123. Yes, sir, Your Lordship.
JJDC?
Yes. Sir, as additional.
Yes, any objection?
No. Sir, I humbly for this letter. Let this matter be taken up on next Tuesday.
We'll see. We'll give it a 1 week on pre-made by the
Sir, please, I humbly pray for next Tuesday only.
next week, so we'll take it up next week. This is matter of the 1 week.
Please, Your Lordship, I beg to mention item number 1, Lordship. I pray for 1 week time, Lordship, because the counsel for the petitioner is currently unavailable due to personal difficulties, Lordship.
You're for?
I'm for the petitioner, Lordship.
Respondent? It's also an old matter. And this matter was part heard, isn't it?
Just 1 week, Lordship.
On pre-made by the petitioner, on grounds of personal difficulty of the learned conducting counsel. Matter is adjourned. This is after 1 week.
I beg to mention item number 11, Lordship. Number 10, Lordship. Here I pray for 2 weeks time, Lordship.
You're for?
I'm for the respondent, Lordship. Sorry.
For the petitioner, Lordship, in item 10.
Any objection?
No, Lordship.
No objection.
You are respondent?
Respondent 4 and 5. 4 and 5.
I'm for the state respondent.
On pre-made by respondent 4 and 5. Not objected to by petitioner. List this matter after 3 weeks.
I do oblige, Lordship.
Lordship, I beg to mention item number 3, Lordship, from the hearing list. It's a joint prayer, Lordship.
Yes, sir.
Lordship.
I think this court has indicated that this matter will be taken up.
Difficulties, Lordship, the senior counsel is out of station, Lordship. So, small accommodation, Lordship. 1 week time may be given, Lordship.
2014 matter.
May not quite
And today, looking at the board, we have ample time to be heard.
understand. Difficulties, my lord, he is not here, my lord. Instructions.
Yes. Anything?
Lordship, due to some personal difficulty, even Dr. Mozika is.
It's a joint prayer, Lordship.
Yes, Lordship. He's not able to appear before this court.
On pre-made by the parties. Matter is adjourned. Even though it is noted that this is a very old pending matter, since the parties are reluctant to pursue the same diligently for ends of justice, the court would accede to the prayer made. It is, however, made clear that the parties will make an effort to be heard in this matter on the next date fix. This is matter after 1 week.
Lordship, similar prayer for item number 4, Lordship.
Four, I think this.
Mr. Sivashi Sen also is there in that.
I think it's only for notice, isn't it?
Not on this matter at the moment.
Yes, yes. You were appearing earlier, but the respondent has since deceased.
Correct.
So
I have not received any instructions for filing of application for substitution as yet.
But the Deputy Commissioner, I am representing, my lord. The case is basically against the action of the Deputy Commissioner, which has been taken on the complaint by the my other private resident.
Petitioner.
Not petitioner, the
On the
respondent.
complainant, or complaint made by the complainant.
Is to
But
ascertain.
according to them, I have no role in this matter. So if they wish to proceed with this matter in my absence, they can choose to do so. So I don't see how the matter can proceed in my absence. The entire duty of substituting lies on them, not on me.
Exactly, their duty is.
So they're not doing it.
You should do it.
We'll take instructions, my lord, to that effect, my lord, because that is again, my lord, a question, my lord, which has to be looked into, my lord, whether we have to substitute the same, my lord.
But any cause survives as far as the respondent one.
Respond number one.
Submission has been made at the bar that the respondent number one is since deceased. Mr. S. Sen, learned counsel, who has earlier appeared for the said respondent, has submitted that he has no instructions in this matter.
Ultimately,
But you have not been officially disengaged. Not officially disengaged.
Well, the client is no longer alive, so I can't represent anybody else. The legal aids are not on board.
Legally, so not. Unum to in this matter, in view of the fact that the said respondent is no longer, in view of the fact that the respondent has since died, and no instruction as far as legal heirs or legal representative
with the grandson of the
approaching the said counsel. The learned counsel for the petitioner, on the other hand, has submitted that he may be allowed to seek instructions as to how the matter is to be proceeded. On premium, let's this matter up to 1 week. 1 week. 1 week.
My lord, item number 5, my lord, the hearing is concluded, my lord. It is fixed for filing written argument. My lord, I am praying for 2 days time. By next week, I will be filing the written argument.
we have concluded the hearing and
We submitted the report,
the records.
records, Lordship. And Lordship, if I may just submit, I was going through the record. Some deposition with regarding to the inquiry. It seemed like it was not there in this particular file.
I also have gone through the records, my lord. There is no deposition.
Two weeks back, Your Lordship, immediately that day itself, we had a meeting, we called the officers. So they have the file, we had got a piecemeal statement only. So we have recorded them to please kindly give me the format of that. So, Your Lordship, I also will require time.
I think one of the grounds of the petitioner is that he was not
No
given the
witnesses has been examined.
chance to cross-examine.
Absolutely, Lordship. So because it's very old file, Lordship, so they were recording and we were trying to do, but we realized, Lordship, that
It is not part of the record.
that was not part of this particular file. So we have written back to the department, Your Lordship, and we got some documents, but again not complete documents. So we'll try to bring that on record, Your Lordship, as soon as it's available.
Mr. K. Khan, learned AAG, has submitted that to the relevant records pertaining to this case has been produced before this court, and the said file is also in the custody of this court. However, on perusal of the records, it is found that there are some relevant documents and papers, particularly with regard to the deposition of the witnesses against the delinquent in the relevant proceedings, the same are not in the set records, and as such prayer is made to produce the same before this court. On prayer made, same is allowed. Let necessary steps be taken by the state respondent to be complied with within the next date fix. This is matter of 2 weeks.
2 weeks. Obliged.
Please, Your Lordship, I beg to mention item number 7. Yes, Your Lordship. Your Lordship, the
You are
conducting
for?
counsel is on leave. I am for the petitioner.
If she has not asked for time, you would have asked. Definitely. On prayer made by the petitioner, this is matter of 2 weeks.
Your Lordship, 8-9 also is a related matter, Your Lordship.
7, 8, 9 then.
Your Lordship, I beg to mention item number 11.
On prayer made by petitioner, this is matter of 3 weeks.
Obliged, Your Lordship.
Supplementary cause list, item number 1.
May it please, my lord. My lord, with your lordship's permissions, I will make some submissions, my lord, in this matter. My lord, pray your lordship's indulgence to kindly direct the petitioner, my lord, to make us a necessary party in the extreme revision petition. My lord. What I'm trying to say, my lord, is that...
File an impleadment.
My lord.
My
Lord, here, I am one of the parties
Who
to
are
the
you?
instant suit. My lord, I am one of the parties to the in the title suit, my lord. Now, my lord, here what has happened is that the trial court, as part of an order, my lord, directed the parties to maintain the status quo. My lord, in the meantime, while the status quo is an operational, the Superintendent of Taxes has issued a letter wherein directing the license holder as well as the bookmakers to surrender the licenses, wherein we have been compelled to surrender our license and to meet it and to merge along with one of the organizations approved by the government. Now, my lord, here, what I humbly pray for your lordships is that a direction may be issued, my lord, and I may be allowed to impede in the incident matter, and I may be heard before your lordships.
You are arraigned as one of the defendants.
My lord.
But if I recall correctly, I think Mr. Sen has submitted that there is no, relief sought against you particularly.
My friend is before lordships on a different issue altogether. For that, they filed a miscase before the trial court. They have never pursued that miscase. They want a stay in relation to a subsequent communication. They filed a miscase for stay, but they don't pursue it themselves. They never come for the hearing. They've said that we are not interested in the matter at the moment. They've made that statement before the trial court.
In the trial court?
Yes, yes. Today it's a concerted appointment between them and the respondent. They are in collusion, which is why they are here today. They want to try and avoid this hearing today. As I stated, lordships will determine the objection that has been raised by the respondent on Order 41 Rule 20. Lordships find my petition is not maintained, it will go. They don't have to put in other people to come and raise their objection on their behalf. This is a proxy objection.
No, man.
This is not a genuine objection. His grievance is related to a different communication. For that, he's already approached the trial court. But he's not pursuing the matter there himself. They can't raise it before this court in a different case altogether. This matter only relates to the issue of license.
But you have made him a defendant in your...
I understand. Lordships will kindly appreciate what he's asking for. He wants to be made a party because his grievance is with regard to a different communication. For that communication, he's already before the trial court.
For which he was directed to merge and for which his license has been...
Correct. So that is a completely different issue. That is not related to the impugned communication here. He's already before the trial court. He can obtain his remedy from the trial court itself. But they're not pursuing it themselves.
But even then, my lord, if any orders or directions come out from your lordship, this may be affected to my lord.
So I'm pointing out it will not affect, and lordships will decide that under Order 41 Rule 20. Lordships find it is connected. Lordships will make them a party.
True.
That's all.
But then you have to file an application then.
Precisely.
My lord, we'll file an application, my lord.
But that cannot stop my hearing, because as far as the other parties are concerned, they've already filed an application for impleadment. Lordships have already held that first the issue of maintainability will be decided. If it is decided against me, the entire matter goes. Then those impleadment applications will not be necessary. If it is held that it is maintainable, then their application will be considered. So they can very well file an application, but they can't try to stall the hearing.
No, I'm not trying to solve any hearings, my lord. Only my humble submissions, my lord, only to implead myself.
So we'll have to see, this court has to think it.
My lord.
I don't want to be, left in a quandary as to what is to be done first. Taking a phrase from you, putting the cart before the horse, or where the situation, how the situation will emerge in the backdrop of the court being incumbent to accord equal opportunity to all concerned. Whether rightly or wrongly, that's a matter of hearing. But at this point of time, you have also approached the court very late. This matter was has been pending for quite some time, since 2021. Now we are in 2023. Where were you all along?
Well, I was pursuing, my lord, my right.
No, nothing has come forth. Latches can be attributed to you.
Lordship, anyway, I'm only on the issue of maintainability. They've raised the question of maintainability. I'm only answering that. If they wish to be made parties, that will be answered later. If Lordships find that I have not arrayed necessary parties, Lordships will dismiss my application or pass an order for impleadment. That will happen. They don't need to be aggrieved with that. If at all Lordships find that I have not made parties, Lordship will pass a direction, I'll make them parties.
Mr. Sen, now, prayer has been made to allow them to be impleaded, for which an application is yet to be filed.
Yes.
So now the court has to decide whether that will be allowed or not.
Right.
If the court is to allow, then the court will have to allow.
No, Lordships, for that I'm saying they will file an application.
No, but the hearing, you see, perchance, the hearing is concluded today.
Lordship. Only on maintainability. Not on the main issue.
Whatever the case may be, if the hearing is concluded today, just for discussion's sake, judgment is passed.
Lordship.
In the meantime, there will be a stop from filing their application.
I don't see that as correct, Manoj.
In these proceedings.
Be that as me, even in these proceedings, we are only on the issue of maintainability of this case. If Lordships hold that my revision application is maintainable, then Lordships will proceed to hear it on the merits. At which point, by next week or whenever, by Monday they can always file.
I thought we were going to hear the matter in
Mr.
its
Mosika is
entirety.
not here, but I believe Lordships had fixed this matter for hearing only on the maintainability. Only on the maintainability. I was answering those three questions, the three objections that were raised by the respondent. That's all, Manoj. I'm only on that point.
But I believe it would be prudent to take up the matter.
If Lordships say that, I'm very happy to argue the entire matter today.
See, the maintainability as well as the merits will be taken up. If you are not, the petition is not found to be maintainable, then it's struck off. If it is found to be maintainable, then the merits will be discussed.
Lordship. So I am ready to do that, but I feel this course of action adopted by a proxy litigant who comes before this court and merely makes an oral submission that I want to be impleaded, so therefore please stall the hearing. That is not acceptable.
No, I'm not praying
The
for
cause that he is espousing before the court is with regard to a different communication which has no bearing on this case whatsoever. Kindly appreciate that, fellows. It has no bearing whatsoever. I am before this court repeatedly on many dates.
Apparently, it looks like.
On many dates. I don't understand what is the issue here. They filed an application before the trial court in relation to a completely different cause of action. They don't pursue it themselves. So for that, should my revision application suffer? I'm only doing the hearing for the maintainability. Lordships will kindly hear my three. I've already completed on one objection. I'm to deal with the other two objections. And they'll answer it on the next date. If hearing is not to be conducted, then my lords, I have nothing to do. I'll have to withdraw from this brief and hand over the brief to the Advocate General because I cannot pursue this matter in this manner. Tomorrow there'll be a third party who will come before this court and say, I want to be impleaded, so please stall the hearing. So I'll leave it to lordships. If the hearing is not to be conducted, then I can't really do much about it, my lords.
But again, if you have to confine, you see, to the issue of maintainability,
Lordship.
then that would be a different cup of tea.
My lords, I have already started the hearing. I don't know if this is even permissible. Somebody comes and says, don't hear them anymore. It's basically the prayer before this court is, please don't hear this matter anymore. Keep it pending for as long as possible so that somebody else can enjoy a stay order before the trial.
What we can do is, Mr. Sangma, what we can do is this. Since this, see, the case is slated today for hearing, the petitioner will be heard. Okay, let's take it this way, that the petition will be heard on maintainability, leaving aside the issue of merits on a later date. In the meantime, you can file your application. And if at all, as Mr. Sen has submitted, if at all the petition is found to be maintainable, then everything will be taken into account. Since you have not provided any applications, no order can be passed.
Kindly recall, the respondent had taken a plea that my friend's application for impleadment cannot be heard till the maintainability is heard. So now some other proxy litigant under their instructions comes and says, no, this matter cannot be heard at all. Now even maintainability cannot be heard.
Now, my lord, here, since I am one of the parties to the original suit, my lord, to the main suit, now they ought to be made to be a party to me.
So that is an objection which the respondent has already raised. Three people don't need to raise the same objection. Lordships are hearing that matter. I've already placed judgments. Yes. I was in the course of placing those judgments itself. The respondent has already placed 2 judgments for the proposition that because somebody has not been made the party, so this appeal is not maintainable. I have already distinguished those 2 judgments. I'm placing some judgments in support of my case. Yeah, I'll pray Lordships will kindly hear my part.
I will hear you.
Lordship, kindly hear my part.
What you can do, Mr. Sama, you do that. In the meantime, Mr. Sen will be heard. You can file your application today, tomorrow, whatever. It's up to you. And when the matter is put up before the court, then the court will take a call on that.
But for Lordship's convenience, I've just made a compilation of all the judgments that I'll be relying on. I've supplied a copy to the respondents as well. Just take another one. Yeah.
Yes.
The first judgment is the one from 1990 Supplement SEC 801.
Yes.
It's a short judgment, Lords. May I just read the entire thing along with the facts of the case? I'll start from para 2 onwards.
Yes.
This appeal arises out of a suit filed by the appellant State Bank of India for a money decree against the partnership firm, defendant number 1, and its 4 partners, defendants 2 to 5. The trial court passed a decree against the firm, defendant number 1, and 2 of its partners, defendants 2 and 4, and dismissed the suit against the remaining partners, defendants 3 and 5. Defendants 1, 2, and 4 did not file any appeal against the decree. The appellant bank challenged the decision of the trial court. So far, it dismissed the claim as against defendants 3 and 5, but did not implead defendants 1, 2, and 4 as parties to the appeal before the High Court. On a preliminary objection against the maintainability of the appeal, the High Court held that defendants 1, 2, and 4 were necessary parties, and in their absence, the appeal was not maintainable. Accordingly, the same was dismissed by the impugned judgment. Mr. Solicitor General, appearing on behalf of the appellant, has contended that defendants 1, 2 and 4 were not necessary parties and the decision of the High Court is illegal. He has further said that even assuming that the 3 defendants should have been impleaded as party respondents, the High Court ought to have added them as such by exercising the powers under proviso of Order 41 Rule 20 of the CPC. Mr. So-and-so, the learned counsel for the respondents, has supported the view of the High Court by saying that if the facts and circumstances of the case are properly analysed, it will be clear that the defendants 3 and 5 could not be saddled with the present liability. The argument of Mr. Solicitor General is well founded. The question as to whether a decree against defendants 3 and 5 should be passed or not is one dependent on evidence and cannot be considered at this stage. The High Court has not relied on this aspect and has refused to go into the merits of the case of the parties by deciding the preliminary point against the appellant. The question of maintainability of the appeal cannot depend on the ultimate conclusion of the disputed issue between the parties about the binding nature of the debt on defendants 3 and 5. We must confine ourselves to the question as to whether the defendants 1, 2 and 4 are necessary parties. They are clearly not so. A decree has been passed against them by the trial court, which, having not been appealed, have become final. Now, when the other defendants are also held liable for the debt, the defendants 1, 2 and 4 cannot be prejudiced. In case the present appeal is allowed, the decision is not going to adversely affect defendants 1, 2 and 4 at all. On the other hand, they will find the other partners sharing their burden. There still is another aspect which has been completely lost sight of by the High Court, namely that the firm defendant 1 represents all 4 partners and has suffered a decree which has become final. In other words, the defendants 3 and 5 should prima facie called upon to share the burden. By dismissing the suit against them, an anomalous position has been created. However, we are not expressing any concluded opinion on this part, as their individual liability is, according to the learned counsel for the respondents, limited on account of the circumstances pointed out in the judgment of the trial court. In any event, defendants 1, 2 and 4 cannot be held to be necessary parties so as to render the appeal in their absence not maintainable. We accordingly set aside the impugned judgment of the Honourable High Court and remit the appeal to it for a fresh decision in accordance with law. The second judgment, my lords, is 2014 volume 13 SCC page 662. Again, this is also a very short judgment. I'll just read the entire thing from para 1 onwards. Lordships have that at page 3.
Yes.
Leave granted. Heard the learned counsel for the parties. The arbitrator made an award dated 22/12/2005 on an amount of so-and-so in favour of the appellant and against the respondent. The respondent filed an application under section 34 of the Arbitration Act of 96 for setting aside the award numbered so-and-so and held the learned single judge of the High Court of Delhi by his order dated so-and-so set aside the award. Aggrieved, the appellant filed FAO number so-and-so before the division bench of the High Court, and the division bench of the High Court, instead of deciding the appeal of the appellant against the order of the learned single judge, set aside the award, holding that the appeals of the appellant were not maintainable, as it was for the appellant to have ensured the presence of the parties likely to be affected in the proceedings in the appeals. The learned counsel for the appellant submitted that it is only the respondent who had filed the application for setting aside the award under section 34 of the Act before the learned single judge, and no other party had applied for setting aside the award before the learned single judge. As the learned single judge has set aside the award at the instance of only the respondent before us, in the appeals filed before the division bench of the High Court, the respondent was the only necessary party, and it was not at all necessary for the appellant to have impleaded other parties in the appeals, even though they may have been affected by the award. We find a lot of force in the submission of the learned counsel for the appellant, and therefore we allow these appeals and set aside the impugned order of the division bench of the High Court and remand the matter back to the division bench of the High Court to consider the merits of the appeal and the appellant against the order of the learned single judge, setting aside the award and dispose of the same as expeditiously as possible. This third judgment is a judgment from the Honourable Guwahati High Court at page 5. This is the citation is 1988 to GLR 421.
Yes.
May I take Lordships to page 6. This is also a very brief judgment. I'll read the entire thing. Page 6 onwards, my lords.
Page 6.
Page 6.
Yes.
May I read, my lords?
Please.
This appeal arises from the judgment and decree of the Assistant District Judge Tezpur in TA number so-and-so, reversing the judgment and decree passed by the Munsif Mangaldoi in TS number so-and-so. The plaintiff Paul Burgoyne instituted TS number so-and-so against 5 main defendants and 2 pro forma defendants claiming for declaration of title to suit land and khas possession of the same on the footing that the plaintiff purchased the suit land from the pro forma defendant number 6, Kandura Daimari. The learned Munsif decreed the suit. On appeal, the Assistant District Judge set aside the decree and dismissed the suit. Hence his appeal to this court by the plaintiff. Mr. P. N. Goswami, the learned counsel for the appellant, has submitted that in the lower appellate court, the pro forma defendant number 6 was not made a party, and therefore the findings of the trial court that the pro forma defendant number 6 had his right, title and interest in the suit land could not be reversed by the lower appellate court without making the pro forma defendant number 6 as a party respondent in that appeal, as was constituted. The addition of a defendant whom the appellant has not made party respondent, the appeal is provided under Order 41 Rule 20. Order 41 Rule 20 runs as follows. I'll just skip this and I'll come to para 5. Para 5 reads, Order 41 Rule 20 CPC empowers the court to make a party respondent if the following prerequisites are satisfied. First, the proposed party respondent was a party to the suit in the court from whose decree the appeal is preferred, but who has not been made a party to the appeal. Secondly, it appears to the court that the proposed party respondent is interested in the result of the appeal. The expression interested in the result of the appeal indicates that the interest of the defendant who was not made a party to the appeal by the appellant is likely to be prejudiced by the determination of the appeal as constituted without making that defendant a party respondent. Keeping the above principle in view, let me now examine the case on hand. As earlier stated, the case of the plaintiff was that he purchased the suit land from the pro forma respondent number 6. The pro forma means pro forma means as a matter of form or for the sake of form. In the context of the case, a party against whom no relief has been claimed. Therefore, the plaintiff respondent was the real contestant in such a situation. Pro forma defendant number 6 was sufficiently represented by the plaintiff respondent, and the interest of the pro forma defendant number 6 was not likely to be prejudiced by the determination of the appeal as was constituted by the lower appellate court. All 3 judgments, my lords, will find all that is to be examined by the court is whether the parties who have not been made parties to the appeal or the revision application, whether they'll be prejudiced by the outcome of this particular appeal. If lordships will kindly have the affidavit that I had filed on 21st of February 2023, I will just take lordships to the impugned communication which was under challenge before the learned trial court.
Yes, this is the miscase.
No, an affidavit, my lords, we had filed to bring on record the entire application as well as the impugned communication. Okay. We filed this with the leave of the court on 21st of February 23.
Yes.
Lordship. Lordship, my lords will kindly keep this application handy because I'll be referring to this application. So the impugned order, which is under challenge before lordships,
yes,
was passed in a miscase filed by the respondents, which is at page 4 annexure 1 to this affidavit.
Yes.
So here their grievance was in relation to a communication that they had received from the state, which is at page 20, the last page of the affidavit. So this is a communication dated 22nd of January 2021 at page 20.
Yes.
This is a communication dated 22nd of January 21 issued by the Commissioner of Taxes to the respondent.
Yes.
So kindly see the contents, my lord. Subject order. You were found to have been conducting the game of arrow shooting without holding a valid license as organizer under the Meghalaya regulation of game of arrow shooting and sale of T-ticket so and so, thereby violating so and so provision framed under the said act. Therefore, as instructed by the government-wide letter number so and so dated 13 January 21, copy enclosed, you are hereby directed to cease the operation of arrow shooting under the said act with effect from the date of issue of this order. Now, as I had pointed out earlier, as per the facts of the case, there are about 4 organizers. Now, this letter has been issued only to the respondent, one of the organizers, only in relation to the suspension of their license. It has not been issued to anybody else. This is only in relation to their license particularly. So, if Lordships find that my revision is maintainable and if Lordships find that the stay was incorrectly granted and vacate the stay order, it will only affect the respondent. It will not affect anybody. By no way can they advance any factual argument to establish that this particular letter affects anybody else. It has not been issued to any of the other organizers. So earlier a friend of mine was before Lordships asking to be impleaded. He has not been able to factually show how this letter affects him in any way. This will not prejudice him. Whatever the outcome may of this revision application, it will not prejudice any of the other parties to the main suit. So that was the limited issue on the first objection in relation to Order 41, Rule 20. The second objection that they had raised is that my revision application has been filed after considerable delay and therefore it is barred by limitation.
Yes.
As for that purpose, kindly note 2 dates, my lord. The impugned judgment passed by the learned trial court confirming a stay in favor of the respondents was passed on the 8th of August 22.
Where is it?
That is in my main revision application at page 152.
One
152 minutes. In extra 25.
152 is the last page of one order.
May I just assist my lords for a moment? My lords, I think lordships have taken up the first revision application. We were hearing the second revision application, my lords.
Oh.
CRP 36.
This is the impugned order.
Lordship. 8th of August 22.
Yes.
By this particular order, this was passed in Miss Case number 1H of 21.
Yes.
So by this order, the learned trial court stayed the operation of the last letter that I had referred to, 22nd of February 21. So the 2 dates that are relevant, my lords, the impugned order was passed on the 8th of August 22. Our revision application, CRP 36, was filed on 8th of December 22.
Yes.
So
8th of December.
8th of December 22. So the total number of days in filing this revision application was about 120 days. Now, if we go by Article 131, which refers to revision applications under CPC filed under Section 115, the time period allotted is 90 days. That is the time prescribed, as Lordships are aware. In that event, the delay would be a total of 30 days. That would be the delay. 30 days, as Lordships are aware, is not an inordinate delay. It's a very minimal amount of delay. If Lordships will kindly have the compilation of judgments.
But have you filed any application for
No, I have
confirmation?
not, because this is not an application under Section 115. This is under 227. This is filed under the constitutional powers of this court. So, the Limitation Act only applies to a revision filed under Section 115. It does not apply to a revision under Article 227. So, for that, I have a judgment on this issue. Kindly have page 9 of my compilation, my lords.
Yes.
The facts of the case are discussed.
Yes.
Are discussed at page 10, para 2 onwards. There are only 3 paragraphs which are relevant in this: para 2, para 3, and para 4. I'll just read from para 2 onwards, Manoj.
Please.
Para 2 reads, the appellants herein, who are the widow and minor daughter of the deceased, filed the claim for compensation because of the demise of Gautam Mazumdar in the said accident before the Motor Accident Claims Tribunal, City Civil Court, Calcutta. MSCT went ahead with the trial and recorded the evidence of the parties. However, ultimately, by its order dated 18/6/2009, MACT held that Kolkata Court did not have territorial jurisdiction to entertain the same and returned the said petition filed by the appellants for presentation thereof in the court of law competent to decide the said claim. The appellants filed review petition against the order, which was also dismissed by orders dated 10/4/2013. Challenging this order, the appellants filed petition under Article 227 of the Constitution in the High Court of Calcutta, which has been dismissed by the High Court on the grounds of delay and laches, stating that though MSCT had dismissed the review petition of the appellants, vide orders dated 10/4/2013, revisional application challenging the order was filed only on 3/3/2015 after a delay of almost 2 years. Challenging that order, the present special leave petition is filed, in which we have granted leave as aforesaid. It is an admitted position in law that no limitation is prescribed for filing application under Article 227 of the Constitution. Of course, the petitioner who files such a petition is supposed to file the same without unreasonable delay. And if there is a delay, that should be duly and satisfactorily explained. In the facts of the present case, we find that the High Court has dismissed the said petition by observing that though there is no statutory period of limitation prescribed, such a petition should be filed within a period of limitation as prescribed for applications under Article 115 of the Civil Procedure Code. This approach of the High Court cannot be countenanced. As mentioned above, in the absence of any limitation period, if the petition is filed with some delay, but at the same time the petitioner gives satisfactory explanation thereof, the petition should be entertained on merits. So 2 things, my lord. Number 1, 30 days is not treated to be inordinate. It is a very minimal amount of delay. Of course, if there is an inordinate delay in approaching the court, one would have to offer some sort of explanation at least. But more importantly, the law of limitation as has been held here does not apply to petitions under Article 227. That is one aspect. The third objection that they had raised, my lords, is that my revision application is not maintainable, and the ground was that what is available to me is an appeal, a statutory appeal before the appellate court. Now, for that, may I just take lordships back to my affidavit, which I had filed on the 21st of February.
Yes.
Kindly have page 4. Page 4.
Annexure 1.
Yes, lordships. This is a copy of the application which was filed by the respondent.
Yes.
Seeking a stay of the operation of that impugned communication. Now kindly see the cost title of this application. It reads an application under section 94E of CPC read with section 151 of CPC praying for appropriate order staying the operation of the letter under memo number 220121 issued by the opposite party number 2. And kindly again have the prayer of the party at page 8.
Yes.
This reads, in the premises aforesaid, it is prayed that your Honour may be pleased to pass appropriate order staying the operation of the letter under memo number 221221 issued by the opposite party number so and so and may pass further orders as your Honour may deem fit and proper. So they were only asking for a stay of the operation of that particular communication, and the petition sought to invoke two provisions. One is 94E and the other is section 151. Now these are both distinct provisions, my lord. Kindly have section 94.
Yes.
May I read, my lords?
Please.
Supplemental proceedings. In order to prevent the ends of justice from being defeated, the court may, if it is so prescribed, kindly underscore these words, my lord, if it is so prescribed. And then lordships will find there are about 5 different situations that have been enumerated here. I'll just read out all. A. Issue a warrant to arrest the defendant and bring him before the court to show cause why he should not give security for his appearance, and if he fails to comply with any order for security, commit him to the civil prison. B. Direct the defendant to furnish security to produce any property belonging to him and to place the same at the disposal of the court or order the attachment of any property. C. Grant a temporary injunction and in case of disobedience, commit the person guilty thereof to the civil prison and order that his property be attached and sold. D. Appoint a receiver of any property and enforce the performance of his duties by attaching and selling his property. And E. This is the provision particularly that they've invoked. Make such other interlocutory orders as may appear to the court to be just and convenient. Now,
Yes.
the respondents are trying to make out the case, and that is their objection, that my remedy does not lie before this honorable court by way of a petition under Article 227, it lies before the appellate court. Now, since it is an interlocutory order, my remedy is not under section 115 because that is barred. My remedy would therefore be under Order 43. Now, Order 43 only allows appeals against injunction orders which are passed under Order 39. Now, in their case, they have not invoked section 94C. If your lordship sees, C relates to grant of temporary injunctions. This is regulated by the procedure laid down under Order 39. Now, lordships may ask the question, why am I suggesting that certain provisions of the court are to regulate C and certain provisions are not to regulate C? As I had pointed out, the opening lines used in section 94 says, in order to prevent the ends of justice from being defeated, the court may, if it is so prescribed. Now, what is the importance or relevance of this expression? Kindly have the definition clause at section 2, subsection 16.
Yes.
Now, section 2, subsection 16 defines this expression prescribed.
Yes.
It reads, prescribed means prescribed by rules.
Yes.
Now, this expression rules has been further defined in
Yes.
subsection 18.
$18.
1-8.
Yes. Please.
Rules means rules and forms contained in the first schedule or made under section 122 or section 125. Now in this particular case, 122 and 125 do not have any application, but what it also says is the rules and forms contained in the first schedule. Because under the CPC, the first schedule contains rules 1 to rule 151. Rule 1 to 51. Now, so therefore what this basically lays down is that the court may grant some sort of an interlocutory order as long as it is prescribed by the rules. So therefore, unless and until there is a specific rule regulating the grant of that particular order, the court cannot grant any such order, any interlocutory order. So as I was pointing out, under section 94, they did not invoke 94C, which regulates grant of temporary injunctions. Even then, the grant of temporary injunction would be regulated under 39(1) and 2, as lordships are aware. Their case is for stay of the operation of a communication issued by the Commissioner of Taxes that does not fall within any of the grounds enumerated under 39(1) or 39(2). I'll just refer to a judgment on this issue. Kindly have my compilation again, Malal. Page 26 thereof.
Yes.
This was a judgment rendered by a bench of 3 judges. I'm reading out the judgment rendered by the majority at page 36.
Para 6.
Para 6 onwards.
Right.
May I read notes? This CPC in 1908 applies to all proceedings in courts of civil jurisdiction subject to any special or local law or any special jurisdiction under any other law for the time being in force. The main feature of the code is its division into 2 parts. The main body of the code consists of sections which create jurisdiction, while the rules indicate the manner in which the jurisdiction has to be exercised. Section 9 states that the court shall have the jurisdiction to try all suits of civil nature except suits which are expressly or impliedly barred. Section 9 falls in Part 1 CPC, which deals with suits in general. Part 2 deals with execution. Part 3 CPC covers Section 51 to 64. Under Section 51 CPC, subject to limitations and conditions as may be prescribed, the court may order execution of the decree by delivery of any property specifically decreed, by attachment and sale, by arrest and detention, by appointment of receiver, or in such a manner as the nature of the relief granted may require. Therefore, attachment is a part of execution process. Part 3 CPC deals with incidental proceedings like power of the court to issue commission, letter of request, etc. Part 6 CPC, now this is relevant, Manoj. Part 6 CPC deals with supplemental proceedings which cover Section 94, which inter alia empowers the court to pass interim orders depending upon the circumstances prescribed by the rules. In the case of Manohar Lal Chopra versus so-and-so, it has been held that the effect of the expression, if so prescribed in Section 94 CPC, is to prescribe the circumstances in which courts can exercise or grant a particular relief, and ordinarily the court is not to use its inherent powers to make the necessary orders in the interest of justice, but to see whether the circumstances of the case come within the prescribed rule. Therefore, in a case where the plaintiff seeks temporary injunction, courts have to ascertain whether the facts of the case fall under Order 39, that it is in the incidence of exercise of powers of the court to issue temporary injunction that Section 94 has a role to play, and that Section 94, however, does not take away the right of the court to exercise its inherent power. In the same judgment, Section 151 CPC is also analysed. The Apex Court in the same judgment has held that inherent power has not been conferred upon the court by Section 151 CPC. It is a power inherent in the court by virtue of its duty to do justice between the parties before it. That Section 151 merely recognizes the existence of the inherent power of the court. Therefore, even if in a given case circumstances do not fall under Order 39 CPC, the courts have inherent jurisdiction to issue temporary injunction if the court is of the opinion that the interest of justice requires issue of such interim injunction. In the case of so-and-so, it has been held by this court that the inherent power of the court under section 151 CPC is in addition to and complementary to the powers expressly conferred under CPC, but that power will not be exercised in conflict with any of the powers expressly or by implication conferred by other provisions of CPC. If there is express provision covering a particular topic, then section 151 CPC cannot be applied. Therefore, section 151 CPC recognizes inherent power of the court by virtue of its duty to do justice, and which inherent power is in addition to and complementary to powers conferred under CPC expressly or by implication. In the case of Jagjit Singh Khanna, it has been held that a temporary injunction may be granted under section 94C. Can you take note of that, my lords? Not 94E, but 94C. Only if it satisfies Order 39, Rule 1 and 2. It is not correct to say that the court has two powers, one to grant temporary injunction under section 94C and the other under Order 39's Rule 1 and 2. That section 94C CPC shows that the court may grant a temporary injunction thereunder only if it is so prescribed by Rule 1 and 2 of Order 39. The court can also grant temporary injunction in exercise of its inherent powers under section 151, but in that case, it does not grant temporary injunction under any of the powers conferred by CPC, but under powers inherent in the constitution of the court, which is saved by section 151 CPC. The above discussion shows that the source of power of the court to grant interim relief is under section 94. However, exercise of that power can only be done if the circumstances of the case fall under the rules. Therefore, when a matter comes before the court has to examine the facts of each case and ascertain whether the ingredients of section 94 read with rules in any order are satisfied. I'll just repeat that, my lords. Therefore, when a matter comes before the court has to examine the facts of each case and ascertain whether the ingredients of section 94 read with the rules in any order are satisfied and accordingly grant an appropriate relief. It is only in cases where circumstances do not fall under any of the rules prescribed that the court may invoke its inherent power under section 151 CPC. Accordingly, the courts have to grant relief of attachment before judgment if the circumstances fall under Order 38 CPC. Similarly, courts will grant temporary injunction if the case satisfies Order 39. So, depending on the circumstances falling in the prescribed rules, the power of the court to grant specific reliefs would vary. Therefore, each set of rules prescribed is distinct and different from the other, and therefore one cannot equate rules of temporary injunction with rules of attachment before judgment, although all are broadly termed as interlocutory orders. So the takeaway from this judgment is that they did not prefer an application for relief under 94C, they preferred it for relief under 94E. Now, even assuming that's a typographical error or that simple nomenclature does not disentitle the court from granting relief, the question would then be, did the court in its duty examine and ascertain under what rule was the court passing the relief? Was it under Order 39 or any other relief? So therefore, they cannot argue the proposition that my revision application is not maintainable and that I must prefer an appeal. The only remedy of appeal that I have is under Order 43 Rule 1R, which requires me to file an appeal against an injunction order or any orders under Order 39. This is not a case where the impugned order has been passed under Order 39. At best, it was the court exercising its powers, inherent powers under 151 to pass the impugned order. Now the question is whether an order under 155 is appealable or not. That has also been dealt with by the Honorable Supreme Court. Lordships will kindly have page 13 of my compilation.
Yes.
So as Lordships are aware, Order 43 Rule 1 lays down all the specific orders which are appealable. 151 does not feature there. Kindly have page 18, para 18, page 20, para 18.
Yes.
Lordships have the para 18.
Para 18.
It is not contended and could not be seriously urged that an order under section 151 simpliciter is appealable. Under the code of CPC, certain specific orders mentioned in section 104 and order 43 rule 1 only are appealable, and no appeal lies from any other order by section 105 CPC. An order made under section 151 is not included in the category of appealable orders. So my only remedy is before this honorable court by way of an application under article 226, because after the amendment of section 115, interlocutory orders cannot be challenged under 151. So my only limited remedy is under article 227. So those are the three grounds that they had raised. I am certain, I'm hopeful that I've addressed all 3 points below. Lordship, kindly ask for a response on Monday and then proceed to hear it on Monday itself on the merits of the case. The merits of the case, again, I'm prepared. The compilation has the relevant judgments.
Yes.
We'll be responding next week, Lordship. Senior's not here today. By next week, Lordship.
So we'll take it up on Monday then?
Tuesday or Wednesday, Lordship. Monday's holiday.
Monday's or Tuesday, Lordship. Tuesday.
Tuesday. Wait, what case name? Abon. Wednesday. Totally. R4 3 kude? So we'll take it up on 20th.
20th. Lordship. Oblige.
But Mr. SN, you are GA
For the
or
petitioner, Lords.
you are GA or you are
Senior Chairman.
senior GA appearing for the petitioner, State of Meghalaya. The respondent has submitted that he may be allowed to state his case in response on the next date. As agreed to by the parties, list this matter on 20th.
Highly obliged.
Item number 3.
Please, Your Lordship. Your Lordship, post yesterday's hearing and upon leave being granted by this Honourable Court, we have filed our additional synopsis of arguments today, Your Lordship. And Your Lordship, we have also placed before your Honourable Court certain authorities to support the submissions made yesterday. So Your Lordship may kindly peruse the authorities. Most relevant page is at page 18 of this additional synopsis that we have filed today, Your Lordship.
Fine. So that will be flagged.
Yes, Your Lordship.
Sir,
Lordships, we filed our written. We're filing our written synopsis as well.
see, when you refer to any authority, have you specifically referred to the relevant paras.
Yes, yes, Your Lordship.
Lordship, I have referred to in one or two where the judgment generally deals with it. I have not, but in all the remaining judgments, I have referred to the specific paragraphs.
Fine.
Wait, Mr. Lordship, so far as the respondent number 2 is concerned, we'll be filing the cause of the
Oh, you are two.
for number 2.
And for respondent number 11 and 12, written arguments will be filed.
Positively to do that.
Also for this thing, respondent, we won't be filing anything. We'll be supporting the claim.
And Your Lordship, for respondent number 3 also, we will be filing.
Fine. The petitioner state of Meghalaya has filed the written synopsis of the argument advanced by the learned GA along with the relevant authorities relied upon. Similarly, the respondent number 2 has also filed.
Respondent number 1, Your Lordship.
Sorry, respondent number 1 has also filed an additional written argument as prayed for and also as allowed by this court. As far as the respondent number 2 and 11 and 12 are concerned, prayer has been made that the said written synopsis may be allowed to be filed in course of the day. The other respondents have submitted through their respective counsel that they will not be filing their written argument. In fact, no argument has been advanced by.
And in fact, Your Lordship, as per instruction for respondent number 3, we don't have much role in this case, Your Lordship. And we are not much aggrieved also by the impugnment.
So whichever way it goes makes no difference to you. As far as the other respondents are concerned, no argument has actually been advanced. Accordingly, this matter is now posted reserved for hearing or for judgment.
Highly obliged, Your Lordship.
Deeply.
Do it in the course of the day, otherwise judgment will not be pronounced.
Lady costless item number 2.
Lordship, recollect that these matters were heard. These were relating to Fifth Pay Commission in Assam Rifle, my lord. Written submissions of both parties were also filed. But in the meantime, my lord, a division bench judgment of this court has travelled to the Supreme Court. The matters in the apex court were fixed in July, my lord. The matter is yet to be listed. That is why, my lord, we had paused in the matter. There is also order to this extent of this court, my lord, previously recorded. So the SLB is here, my lord.
Should we wait?
My lord, it was supposed to be listed. There was no fixed date given.
So we pose it for another 4 weeks?
My lord, another 4 weeks, my lord.
Heard Mr. B. Pathak, learned counsel for the petitioner, who has submitted that the related matter before the apex court has not yet been taken up for hearing, which most likely will be taken up in the month of July. In view thereof, it is prayed that this matter may be kept in abeyance. As submitted, this matter is now list this matter after 4 weeks. In the meantime, the parties are allowed to make a mention if any decision or relevant order is passed by the Honorable Supreme Court relatable, directly related to the subject matter herein. Order accordingly.
Give me a